a few words as an introduction. First of all, it's a great pleasure and honor to host Amelia with us. Not only she is known as a remarkable musician, she is also a senior official in the field of competition policy in the UK. She has several leading roles in the field of competition regulation and beyond. She is also an academic. She co-directs the Center for Competition Policy, which is a remarkable initiative introduced probably 15 or 20 years ago by several academics in Norwich. And from scratch, they have managed to create really leading center of research and policy, synchronizing different economic, legal, and policymaking academics or their research. And it's really an outstanding center. I had a pleasure and honor to be part of it some time ago. And now we have Amelia with us. She will be discussing her ongoing research project, if I understand this ongoing nature, about trying to compare the evolution of the regulation of digital platforms has taken place mainly in the United States and European Union, but I assume you can ask also questions related to the UK jurisdiction. So let me pass the floor to Amelia.
Thanks very much. And now I have got rid of the mute. And thanks very much for inviting me. So yeah, I'm going to be talking about some work that I've been doing with a number of co-authors on looking at international regulatory coherence as we start to introduce more and more ex-ante digital platform regulation. And so the paper is actually referred to as Monika Schnitzer et al. This set of co-authors has written a number of papers together, so we decided to get rid of the old-fashioned going by alphabetical order and choose different of us to be the lead author. Monika was a key author, but I've also done a lot on this paper, but she gets the name on this one. Let me see if I can go on. I should just also say that I am on the board of the Competition and Markets Authority. I won't be talking much about the UK, although I will do a little bit, and I can do in the Q&A, but I am very much talking with my academic hat on. I need to make that clear, not with my CMA hat on, and I have no other conflicts. A lot of people are talking in this space and do have conflicts, but I don't. So if I can make my slide actually go on. Okay, so I thought I would just start by reminding all of us why we are introducing in a number of jurisdictions around the world ex-ante regulation for the largest digital platforms as a complement to antitrust. And this is now quite well trodden, these arguments, but I do think that they are worth highlighting because they feed into how we then actually want to design the regulation. So the first point to make is that an antitrust has proven itself to be really very slow. So the Google shopping judgment has finally come out. I think it's 11 years after that case was started. Most of the players that kicked off the case have essentially disappeared. These are very fast-moving markets, and if antitrust moves that slowly, it will be ineffective. Basically, what we're seeing in a number of digital markets is a few players with very strong market positions, entrenched market positions, and as we go on over time, those positions are becoming more entrenched, and they are also being leveraged into new markets, creating ecosystems which are, ever more difficult. If we don't act relatively speedily, it becomes ever harder to remediate those issues. And what we've also seen actually is antitrust remedies themselves have proved pretty ineffective. So it's another reason why, if we allow the problems to develop, remediating them after the event is non-ideal. So much better to think upfront about what sorts of behaviours we want. The second key point is that antitrust cases themselves, in order to be effective, tend to be quite narrow. And sometimes somewhat esoteric. And what that means is they don't provide really clear upfront rules of the game kind of across the patch. And that's not good for the firms themselves, because it's better for them to have some legal certainty, but it's critically also really important, not only for the users of those firms, but for their people who are trying to innovate in this space and may need either access to those firms to get to consumers, or they may want to compete against those firms, and they need to know all of the rules of the game under which they're going to be playing. And the third point about antitrust is that some drivers of the problems that we see, the economic problems that we see, are kind of intrinsic. So we talked about, I'm sure you're well aware of this, but there's economies of scope and scale. There are network effects. There are feedback loops associated with data. All of those tend to lead to these markets becoming concentrated and tend to lead to market positions being extended into new markets and the building up of ecosystems, even without any strategic anti-competitive behavior on the part of the firms involved. I'm not saying there isn't strategic anti-competitive behavior. There has been, that's I think been shown, but I think we'd see some of what we see without any anti-competitive behavior. And where there is no kind of suggestion of fault, actually antitrust is not potentially the greatest way of dealing with it. So what we have, I was on the Furman panel back in 2019 that you've probably heard of, which recommended for all of those reasons that there needed to be ex-ante digital regulation. Since then, there has been a huge amount going on. In Germany, they've actually introduced a form of regulation, but they've actually done it through competition law. I'm sure you're aware of this. So they have this new Article 19A of the competition law. And there are all these new acronyms, and I'm not going to go through these, but they look at, they can designate firms as having paramount significance across markets and then impose rules on them. In the UK, and I know you've already had a session on the UK proposed digital markets unit, but firms with strategic market status would be regulated, and that legislation is in the process of being finalized at the moment. It's looking like it will go through, but the timeline is somewhat unclear. And exactly what it looks like is still somewhat unclear. In the EU, as I'm sure you're aware, the Digital Markets Act is planned for large online gatekeepers that offer certain core platform services. Again, there are the final negotiations over the legislation right now ongoing. In the US, there have been 5 bills, actually now there's a 6th bill proposed for what they call covered platforms. And so that's that equally will provide a kind of ex-ante regulation, although they don't like the word regulation in the US, so they see it as a set of ex-ante rules that can be enforced by the courts. But essentially the substance is the same. There's also developments in Australia, China, Japan, Korea. I'm going to focus on the US and the EU proposals. Now, in terms of designing regulation, I first of all just want to highlight there's a bit of a false trade-off between, on the one hand, speed and administrability, and on the other hand, perfection. Now, I said that one of the key reasons why we need regulation here instead of antitrust is antitrust takes too long. And that I've also said that because it takes too long, it's effectively it's ineffective. But of course, therefore, if we're going to design regulation, the key thing is how we create regulation that doesn't take too long, where we really do have speed and where the regulation is kind of easily administrable. how do we achieve that? And I think a lot of the thinking about regulatory design at the moment is about how you actually get that speed and that administrability and that clarity about what is required. There is a risk that what is required may not be what would be required if we had all of the time in the world to get to the best answer. And so there is this potential trade-off between speed and administrability on the one hand, and always getting the right answer, not making any mistakes, not having any unintended consequences. I would like to argue that that might look like a tension, but for the reasons I've already outlined, it's a bit of a false trade-off, because actually if we spend finding the perfect answer takes a lot of time and a lot of resource. And time and resource is what we do not have. And if we spend too much time trying to get the right answer, that will actually be the wrong answer. And so while we obviously want to avoid mistakes so far as is feasible, we have to do that recognizing the incredible importance of speed and administrability in setting up these regulations. The other key point that we make in our paper is around international coherence. And we highlight that, I mean, I've already explained that there's stuff happening in a number of different jurisdictions, and there is a real risk of those regulations being incoherent. And that's particularly big risk if they might have extraterritorial effects. I'm sure you're aware, for example, that GDPR, which is an EU regulation, in fact has extraterritorial effect in the US. A number of firms essentially have to comply with at least quite a lot of it. Why? Because actually these are global services. So when I go onto Facebook, I'm engaging with people in exactly the same interface with people in the US. So if they have to satisfy my my European requirements from a GDPR perspective, they essentially also have to satisfy those requirements for the US users, because you can't design an interface that provides the same surface, but has different, that meets different legal requirements. Also, just the cost of these systems is such that there's huge economies of scale. So you want to design one system and then roll it out across as much of the globe as you can. And the more that you have to have different systems in different jurisdictions, the more unrealistic that is. And therefore, actually, if the EU puts in place a whole set of regulations for the EU, the likelihood is that, unless there's requirements otherwise, the firms that have to invest to meet those requirements will just roll that out for the US and the rest of the world as well. So there's big extraterritorial effects here. I think someone's got their mic on. Hi. So that's really risky, because if firms do, so if there's extraterritorial effects, it's particularly serious, but generally it's serious if actually firms end up being required to do different things in different jurisdictions. So there's incoherent regulation that will lead to very high costs for the firms. If there are restraints on their conduct, it could actually make some of their services unrealistic. It could certainly lead to them reducing their quality, raising their prices, or dampening their innovation, none of which are the reasons we're trying to regulate. We're actually trying to regulate to actually improve things. That's the idea of regulation here, and particularly to actually facilitate innovation, not dampen innovation. So there is some real risks around international coherence. I've said these are global services. There's actually also just a pragmatic issue, which is most of the regulations proposed have at least some aspects of proportionality. There's a debate about how much proportionality they require. And clearly, it's going to be more proportionate to do something in the UK if it's already being done in the EU, and and less likely to be proportionate in the UK if the UK is the only place it is being done. So actually, the degree of international coherence will go to whether any individual regulation meets the requirements of proportionality. There's also an issue in terms of international coherence around just basic politics and trade policy, in that rules could be viewed as protectionist. And this has been an issue as regards the EU putting in place the DMA, when actually we know that most of the firms that are of concern here are American. Certainly the four biggest ones that most concerns are highlighted about are American concerns. And we also know that there's a lot of disquiet in the EU that the EU has failed somehow to produce such big and effective companies. And there is some nervousness, I think, in the US and in the EU that the Digital Markets Act could be seen as protectionist because it's against US firms. And I think that's one of the reasons why the EU is in fact trying to enlarge the scope of the DMA beyond what might naturally be sensible, because they do not want, so they're trying to include things like booking.com, for example, I think, because they don't want to look like it's an anti-EU firm regulation. So those worries about protectionism could actually potentially lead to bad outcomes from an economic perspective. And more generally, I think there is this risk of, if the EU goes first and sets a regulatory kind of baseline for what is required of these firms, then the UK comes in and puts in some extra things, Germany comes in and puts in some extra things, and then the US comes in on the top and puts some extra things. There is a risk of building a kind of unwieldy regulatory edifice. And this was just an example of how kind of Lego blocks on a number of areas, the sorts of building up you might see. In fact, as I'll come on to later, the latest EU regulations have already developed, or sorry, the latest European Parliament recommendation on the DMA has already developed a little since I did this figure, and has already moved a little more towards the US position, which means there'd be a bit less of a building up of regulation as over time, but only because the EU is taking a initially more expansive view. But clearly this sort of thing, even if you don't have inconsistency, you could build up this kind of massive edifice of regulation, with each country wanting to add just a little tweak. That said, this is mostly the same slide again, but with an additional bullet at the bottom. I just want to highlight that absolute consistency may be undesirable. These different jurisdictions do have different legal, regulatory, political, cultural contexts. Also, so actually, even if they're essentially trying to do the same thing, it may not be sensible for them to do it in the same way. So you can have coherence without consistency. I would also highlight that coherence across all of these jurisdictions, absolute coherence, could take a lot of time. And obviously time is one of the things I've argued we don't have. So that's another argument against spending too much time getting coherence, but actually ensuring that different jurisdictions just communicate and coordinate so far as they possibly can. And that actually is already happening to quite a large extent. There was a G7 meeting this week, and there was an OECD meeting yesterday with all of the relevant jurisdictions discussing what they're doing and trying to hammer out kind of where the similarities and differences are. And our paper kind of feeds into that debate as well. Another point actually is that if jurisdictions do take slightly different approaches, actually the comparison of those approaches may yield valuable lessons. And we are at a very early stage in designing this regulation. I would say that the regulation we put in now will almost certainly not remain the regulation that is there in, say, 10 years, because we are going to learn so much over the next 10 years, or at least I hope we will. And I hope we'll do that without doing too much harm in the meantime. So I mentioned that convergence is already increasing somewhat. And I mentioned this paper that we published in 2021, which compared the EU and US approaches raised a number of concerns about both, but our particular focus was on inconsistencies between the EU and US proposals in several areas. On the 23rd of November, so last week, the Committee for the Internal Market and Consumer Protection, so IMCO, which leads on the DMA for the European Parliament, adopted its position on the proposal. So essentially, this is now the European Parliament position on the Digital Markets Act. And what that does is actually it accepts many of the recommendations we made. And therefore, in doing so, it actually brings the Digital Markets Act far closer to the US regulatory proposals, which I think is really, really interesting and theoretically good for coherence, although there's a very interesting question mark about actually what's going to happen in the US with their proposals. They are still at the very early stages of negotiation. So actually there is a slight risk here that the European Parliament moves more to the US, but the US actually then starts downgrading, and the European Parliament has in fact not converged, even though it is trying to converge. Difficult issue when everything's moving all the time. In the EU, as I'm sure you guys as lawyers know much better than me, the next stage, I believe, is negotiation between the European Parliament and the European Council. The European Council is less keen on a number of these changes, but actually their biggest concern is likely to be around the precise role of member states in enforcing the Digital Markets Act. And so it is quite possible that a number of the European Parliament's proposed changes on the substantive side will go through. And that's led to me having to do a rapid rewrite of this talk. And indeed, I realize I'm already running low on time, so I'm going to speed up. I don't know actually, how much time do I actually have for this initial bit?
We are very flexible, Amelia. So we have about 1 hour, and depending on the length of your talk, we'll have a shorter or longer time for Q&A.
Okay, very good. Well, I think we'll certainly have enough time for a bit of Q&A. Okay, anyway, so all these changes meant I had to rewrite this talk a bit, and it now has moved away from what the actual paper we have out says. The paper is not yet published in a journal, and so we're probably going to have to massively rewrite the paper as well, because we have it in for a journal. So this is why it is ongoing work at this moment. In terms of thinking about regulatory design, there's a whole set of questions that you need to ask. All of this within the framework that I've talked about, that you really want to ensure speed and you really want to ensure administrability. First of all, you need to think about which firms to regulate, then which activities within those firms to regulate. Then you have to design your rules, and you need to think about how bespoke to be, how much flexibility to retain, versus just having it all laid down in legislation with very little for the same for all firms and very little flexibility. You need to think about what conduct you're actually going to address and how you avoid unintended harm. And I'm going to talk very briefly about each of those topics and how the US and EU, and in some cases the UK as well, have addressed them. So in terms of scope by firm, I mean, basically the challenge is that if you have simple, clear scoping, quantitative is perfect, then that really aids speed and administrability. But it could be over or under inclusive. And what we know is really, outside of China at least, the regulation that we're looking at here has been really motivated by concerns with the top 5, or maybe even just the top 4, but let's say 5 big tech firms. But there is this next tier of big tech firms, things like Uber, Booking, Spotify, which some of the concerns have also been raised in relation to, but nothing like the level that some of these, in respect of some of these other firms. And the second tier are not the same level of gatekeep, don't play quite the same level of gatekeeper role as the main 5 firms. So the big challenge is, how many firms to include, and also how flexible to be in terms of both facilitating future-proofing and also enhancing proportionality. So what have the different jurisdictions done? The US has a completely inflexible, or is proposing a completely inflexible, purely quantitative approach, which basically, as far as I can see, captures the top 5 companies only, no one else. So only, and they're all US companies. So interestingly, the US, despite concerns that the DMA is going to be targeted too much at US companies, the US proposals are only targeted at the US companies. The EU approach is to have a quantitative gateway that gives you a presumption that you should be regulated, but it has a degree of flexibility. So first of all, the quantitative presumption could actually capture more than the top 5. There's still debates over exactly where that the quantitative threshold should be. It's been raised in the latest European Parliament position. But more generally, if that is just a presumption, it can be rebutted, and there are also qualitative criteria that could bring firms in. I actually really like, I have to say, the UK approach, the EU approach on this. I think it's a really neat balance between administrability, but also giving flexibility. The UK approach actually is completely flexible. There's no quantitative criteria. It's just a qualitative analysis of whether firms have got substantial and entrenched market power in a relevant activity, and also a strategic position, and they define what strategic position is. This is pretty flexible. It could capture more or indeed less than the top 5. I mean, my hunch is that in fact, the UK is going to be focused on the top 4 or 5, and has no intention of using the flexibility to bring in additional firms, at least for the moment. But it's set up in the way that it's currently set up in the way that it could. Next thing, though, is you've got your firms that are in. You need to work out actually which of their services are which of their activities are actually going to be regulated. And why does this matter? It matters because actually these firms are very entrenched dominant market position in some markets, some activities, but actually they might be important and innovative entrants into new activities. So, Facebook, for example, very solid position in social networks, as we know, but it's quite a new entrant into the marketplace. It now has Facebook Marketplace. We might want to encourage Facebook to try and compete against Amazon in providing a marketplace function. So they are much needed. They may be much needed competitors against the other platforms themselves in their core markets. So that means we need to be careful not to overly limit their activity where they're not dominant. On the other hand, one of the issues that we're concerned about is actually the firms leveraging their market power from one activity into new activities. And indeed, the Google shopping and the ongoing Amazon marketplaces cases in Brussels were all about leverage into new markets. So how do you get the balance between encouraging that new competition, but limiting leverage of market power? The regulations have tried to address this by focusing the regulation on activities where firms are dominant, but enabling that to address certain obvious leveraging concerns, things like around self-preferencing. Another challenge, so that's one challenge. Another challenge, if you look at Amazon, the Amazon ecosystem is enormous and has loads and loads of different elements. And the question is, which of these are you regulating and which of them are you not? So you might say, well, Amazon is a marketplace and in the DMA it's covered, but are all these things part of the Amazon marketplace? Are they not? Which ones are in, which ones are out? And that's really not a straightforward question. In our view, actually, we thought that none of the different jurisdictions had really thought about that issue sufficiently. And I think it could end up being quite a big issue going forward. In the US, slightly better in that what they've done is they have very much defined what is covered by function. So they basically have three types of a function, essentially things that provide a social network surface, things that facilitate online sales, and things that enable search. And those are kind of the big functions. And then everything that feeds into the function, that those functions is also covered, whether it's the cloud, it's apps, it's anything that feeds into that function. In the EU, they've actually been a bit more specific. So they separate out particular elements of delivery, like operating systems, cloud computing, apps. Actually, app stores are combined. That is arguably a bit more fragile and gameable than the US. On the other hand, what the EU does have, which the US doesn't have, is it has the ability to revise categories and also to apply designation criteria qualitatively. Also, one of the things that our paper highlighted was that the US approach, because it goes by these kind of overall function, it did include browsers, it did include virtual assistants. And we said, actually, we think that's very sensible. They seem to be pretty core and to be actually a core part of the gateway that consumers have to go through to access services, and they therefore absolutely fit well with the idea of a gatekeeper regulation. In fact, the latest European Parliament position includes browsers, virtual assistants, and actually connected TV. So I think that's a big move. We're very supportive of that. It's what we recommended. We didn't think about connected TV, but I think it makes sense. Also, the new European Parliament position on this issue, it clarifies that services within the same category may be viewed nonetheless as distinct if they're used for different purposes. We assume that that means that they may be viewed as non-distinct if they're used for the same purpose, although it doesn't actually say that. But by corollary, you might think it was true. A lot, therefore, may end up hanging on what does for different purposes mean? Are these various things used for different purposes or not? Is Amazon Prime, does that have a different purpose from Amazon Marketplace or not? It has some aspects of different purpose. It has some aspects that seem broadly the same purpose. How do you do that in practice? I think that's going to, for you lawyers, that might well end up being a hotly debated issue. In the UK, as I said, it's all fully flexible. The DMU will go through specific activities individually and decide whether they need to be designated. So that's the scope, just checking on time. In terms of the rules, the question of how bespoke and how flexible to be, I've kind of talked already. And I mean, as a very general point, even these big five firms, people talk about GAFAM and almost as though they're very similar firms. What we know is that they're very different. They are providing very, very different services and functions. And even where they provide similar functions, they often have very different business models. So Google and Apple obviously both have mobile ecosystems and run app stores, but Google is primarily ad funded, whereas Apple is primarily funded by its device sales. Does that matter for the rules that we might want to put in place? It might. And more generally, there's just a risk that rules that are suitable for one firm or one activity may be unsuitable for another. So that's a question about how bespoke things should be. A problem, obviously, with making things bespoke is that simplicity itself has a value. It's less gameable. So firms can't get around the games by the rules by just changing how their services are set up a little bit. There's also a slight concern that bespoke rules risk creating unlevel playing fields. Clearly, Google and Apple are competing against each other. And if you give them different rules, you could actually slightly tip the balance between them. There is also a risk of these that our understanding of these markets changes over time, and indeed that these markets themselves change over time. And that also suggests that we might want to have quite a lot of flexibility or revisability in relation to the rules. So I'm not going to go through this slide in any detail, but just to highlight, and we go through it in a lot of detail in the paper, but the US basically has very standard rules that apply to all of the covered platforms, and they are very inflexible. There is no, at least on the face of the law, there is no way of changing the rules once they're in place. Obviously, you could re-legislate, but there's nothing that allows for easy flexibility and change. The UK is, at least if the proposals of the Digital Markets Task Force are accepted, actually there's very little around the precise rules in legislation, just high-level objectives. And the DMU then has a lot of power to set principles and rules, basically to design these code of conduct. And they can actually decide when designing those rules how bespoke to be, how rule-based versus principle-based to be in each case. And they need to be obviously thinking about things like level playing field in doing so. The EU is interesting because it's kind of semi-bespoke and semi-flexible. Some of the rules apply to everybody, but some of them are only applicable to particular activities. And moreover, there is a specification process whereby the companies can come to the Commission and say that actually we don't think this particular rule is effective and proportionate in our specific circumstance, and they can have that discussion with the Commission and have the measures that they've got to put in place revised as a result. Rules can be revised over time by the Commission following a market investigation to extend or further specify them. And there are also, interestingly, some anti-avoidance provisions in the EU rules, which are designed to stop this kind of gaming process. So actually, again, EU kind of slightly lying between the US and the UK in terms of flexibility and bespokeness. In terms of the conduct, there's a lot of different aspects of conduct that are addressed by these regulations. It gets really quite down to the nitty gritty quite fast. And in our paper, we do get down to the nitty gritty. And I'd be here all afternoon if I was going to present all of that. So I thought I'd just focus on a couple of examples. And actually a big example is around non-discrimination. Here, there's actually a surprising and apparently increasing level of alignment between the US and the EU. In general, the US variants of the specific rules in this space tend to be somewhat more expansive than the EU variant. So the US basically has a general no tying requirement, a no steering through default settings requirement, a no MFNs requirement, whereas the EU proposals were narrower. But the latest European Parliament position in each of these areas is starting to be more convergent, as I said, with the US. So as some examples, the US has a general non-discrimination requirement, whereas the initial EU DMA proposals set a number of more specific obligations. But actually, the latest European Parliament position includes a general ban on self-preferencing as regards access conditions. So that's much more general. And also a specific ban on self-preferencing in ranking that was already there, but it now is added or other settings. So actually there's quite a big increase in the expansiveness around self-preferencing if that goes through. Likewise on MFNs, the initial EU proposal was to ban wide MFNs. So that's where a platform is not allowed to say you can't charge cheaper or have different conditions on another platform. The US went further and banned all MFNs, and the latest European position also bans both. So specifically, it says that the platform can't limit how you sell your product through your own website or in your own store. So that's a narrow MFN, and then that looks now to be banned as well. Personally, again, in our paper, we said we thought that was sensible given the very high market power of these firms, which most of the arguments for why you might want to allow narrow MFNs don't really apply when you have quite such big and powerful firms. Likewise, the US had a general no tying provision. The original EU rules around tying were pretty limited, but there's now a new European position, European Parliament position, to allow end users to access and use content subscriptions, etc., via the core platform service. So, for example, via an app store, even if they've purchased them elsewhere. That's quite a big thing around limiting tying. In terms of other areas of conduct, interoperability is a really key aspect of regulation in this space. And the reason is that actually these are very technical markets, and very often the ability of competition to emerge depends on interoperability. And the original internet was very much built on an open standards, very interoperable basis, but gradually with the development of walled garden ecosystems, interoperability has been reduced essentially, and firms have had to become and it's become more things have become more proprietary, and so interoperability potentially plays a really big role in facilitating competition. The EU focus in the DMA originally was on interoperability for ancillary services like payment services. The US required much more extensive interoperability. It also wanted equitable interoperability. So the idea was that these gatekeepers would have to offer third parties the same interoperability as they offered their own competing services. So the equitability was within the US rules and not in the EU rules initially. And also the US highlighted that it wasn't just for ancillary services, but also for business users, and also, and more controversially, I think, with rivals. So they had to make in certain circumstances, they had to open up interoperability with rivals, which would really facilitate competition. The European Parliament position is considerably strengthened in this area, with strong equitable interoperability requirements. Interconnection is also required, and this is a really big change. I don't know if this particular one will stay. I think it's going to probably be one of the most controversial ones, but interconnection is now required with rival services for both interpersonal communication services. So that means that, for example, if you're using WhatsApp, you should be able to phone someone on Telegraph using your WhatsApp system, for example, and also social networks. So, for example, I should be able to network with someone who is on at least to some extent, and who knows quite what this means, on a different social network using my Facebook account. Our group, by the way, also has a paper on equitable interoperability and gives some thoughts as to what all of this might mean. And I would recommend, I'm not going to talk about that paper, but I would recommend that paper. There's a number of questions. I mean, I think it's far from straightforward, but there are the gains from greater interoperability are potentially huge. So I think it is worth having this debate. The US, how is this done? Because obviously there's a lot of issues around setting standards for example, interconnection. The US proposals were to give the regulator, so the DOJ or FTC or both, a role in overseeing a kind of industry standard setting and implementation body. The European Parliament position, and this may be heroic, is that the Commission shall simply define these standards via a delegated act within 18 months. we'll see how that goes. I think I won't talk about mergers. We can maybe talk about them in the Q&A, but again, it's another area where the European Parliament position has strengthened what is being required somewhat. We really need to have some Q&A. So I've only got 2 more slides, but I think that I will actually just rush through them. Basically, I think you'll be clear that there are some risks of unintended harm here. I'll share these slides afterwards. They just give a whole set of reasons why there could be harm to competition, to innovation, to the user experience, to pricing, to privacy, to system integrity and security, all of these risks if regulation is done poorly. And the question is how you limit the risk of that harm, bearing in mind, of course, that we're trying to ensure the speed and administrability and recognizing that we might make some mistakes. So how do you get the right balance between those? In the UK, there is a general proportionality requirement, although I think there's going to be some really interesting questions about how you achieve the speed and administrability within the UK, that general proportionality requirement. And I think that's all going to come down to timetables and also who has the burden to show what under the system that is put in place. You can also have caveats within specific provisions or rules. So there's elements of this in the currently proposed UK principles, and also the EU obligations. Quite a few of them actually say things like without prejudice to integrity or recognizing the need to ensure privacy. You can also have general defenses, which would then disapply a particular rule in specific circumstances. The EU has a pretty narrow set of public interest exceptions, but it does have this Article 7 specification process that I already mentioned. And actually the European Parliament position, which I'm pretty sure the European Council is already agreeing with actually, is that this should be much more participative, much more potential for third parties to engage, much more for the potential for the firms to come and ask for advice or ask for a view. The US approach doesn't have that much, but it does have the potential for an affirmative defense if the firm can show clear and compelling evidence that its conduct does not harm the competitive process, or that it is required to avoid a violation of the law and protect user privacy. But as I say at the bottom of the slide, I think that getting the balance right between speed and administrability on the one hand and proportionality on the other hand is probably the hardest issue in the whole of the regulatory design question. In conclusion, this is a fast-moving field. It's really hard to keep up sometimes. There's going to be this negotiation in Europe now between the European Parliament and Council that is intended to be completed within the French presidency of the Council, which ends in June. So we'll see, but clearly there's a big incentive to try and get it done quickly. The UK legislative framework is very different in theory, but interestingly, if the DMA gets put in place, because of the extraterritorial aspects that I described earlier, it's likely to become a foundation stone for the rest of the world in practice. So in fact, when the UK is putting in place its rules, it may well end up taking the DMA as a kind of as a baseline, but we'll obviously have to see. So I'm really sorry that I left so little time for discussion, but we have got a bit of time.
Amelia Fletcher, thank you very much for this really illuminating talk. I have to say that we'll have a Q&A session, but it will not be recorded. So for our YouTube viewers, join us next month on our Zoom webinars. You're welcome.